And now for a Next News special report.
Brace yourselves, America, for a groundbreaking revelation as video evidence emerges showcasing Justice Clarence Thomas' powerful words that could reshape the legal landscape. With the Supreme Court's precedent-setting decision in the Colorado case, the stage is set for a seismic shift in Donald Trump's New York City conviction. As we present exclusive footage of Justice Thomas questioning the very foundation of the prosecution, you will witness the unfolding of a legal battle that could redefine the future of American justice. Now, in a nation built on the principles of justice and equality, the Colorado case set a powerful precedent, one that Justice Thomas may now apply to Trump's New York City conviction. Just as the Supreme Court stood firm against unconstitutional overreach, we too must stand united in the pursuit of truth. But the forces that seek to silence us are formidable, and we cannot prevail without your support. By donating to our cause at the link in the description, you're not just keeping our channel alive, you are safeguarding the very foundation of our legal system. In this critical moment, your generosity could be the deciding factor, ensuring that the precedent set in Colorado extends to all Americans, regardless of their political affiliation. Together, we can champion the cause of justice and preserve the integrity of our nation's highest court. Take action in the links below. Now, in a groundbreaking development, Supreme Court Justice Clarence Thomas has now, raised pivotal questions regarding the legitimacy of the special counsel's prosecution of former President Donald Trump. This issue has garnered significant attention, and its implications could be far-reaching. To understand the gravity of the situation, let's first consider the recent Supreme Court decision that unanimously overturned an unconstitutional Colorado ban. Notably, even liberal justices sided with Trump in this ruling, signaling the potential for a strong majority in his favor should the New York court case reach the nation's highest court. Justice Thomas' doubts about the prosecution's legitimacy further underscored the likelihood of a 6-3 or 7-2 decision supporting Trump. The Colorado ruling dealt a severe blow to Democrats, thwarting their efforts to prevent voters from choosing Trump in the upcoming November 5th election. So as we delve deeper into Justice Thomas' perspective and the conservative majority stance, the video evidence becomes increasingly compelling. Listen.
Do you have contemporaneous examples? And by contemporaneous, I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples, because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it seemed that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising, because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting.
So what's the purpose
officer.
what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to.
Now, in this powerful clip, Justice Thomas questions the lawyer defending the guilty verdict, demanding examples of states disqualifying national candidates shortly after the adoption of the 14th Amendment. The lawyer struggles to provide a satisfactory response, highlighting the unprecedented nature of Trump's prosecution. The heart of the matter lies in the absence of a federal crime in the New York indictment. The Department of Justice did not accuse Trump of a federal offense raising serious jurisdictional concerns that fall squarely within the Supreme Court's purview. Former FEC Chairman Bradley Smith and Hans von Spakovsky have unequivocally stated that Trump did not commit a crime, contrasting sharply with the FEC's decision to fine Clinton and the DNC for their transgressions. Watch this.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, you know, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake that at the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately because of this and so many other mistakes made in the case.
How many do you count? How many mistakes?
I lost count of how many errors were made by this judge and by the prosecution. I mean, the judge let in all kinds of irrelevant evidence that had no bearing on the charges against the president, but were obviously there to blacken the character of Donald Trump. The judge shouldn't have even been on the case. He should have recused himself because of his personal family dealings, his daughter's involvement, his making political contributions in violation of the ethics rules in New York. There are just so many mistakes and errors he made that I don't see how a Court of Appeals could not overturn this verdict.
Now, what you just saw is Hans von Spakovsky exposing the glaring absence of a federal campaign violation in Trump's original indictment. He argues that the jury's assertion of a federal crime was a grave error that should compel the New York Court of Appeals to overturn the verdict. Von Spakovsky also sheds light on the numerous mistakes made during the trial, from the admission of irrelevant evidence to the judge's failure to recuse himself despite clear conflicts of interest. Now let's go to Bradley Smith. Watch.
You're saying there was no crime. There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more, and it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard. It's an objective one. So if I go out and I want to pay for TV ads that say, you know, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation.
So Bradley Smith characterizes Trump's prosecution as a travesty and a miscarriage of justice. He meticulously deconstructs the prosecution's flawed theory, exposing the subjective and problematic interpretation of campaign finance laws that underpinned their case. As we await Justice Thomas' full opinion, the video evidence presented today paints a damning picture of a politically motivated prosecution devoid of legal merit. The Supreme Court's intervention appears not only warranted, but necessary to uphold the principles of justice and equality that form the bedrock of our legal system. So the precedent set by the Colorado case looms large, offering a glimpse of the potential outcome that could exonerate Trump and reaffirm the Supreme Court's vital role in safeguarding against unconstitutional overreach. As the nation watches with bated breath the fate of the former president and the integrity of our entire judicial process hang in the balance. If you got value from this report, tap subscribe. It's time for my final thought. The precedent set by the Supreme Court in the Colorado case could be the key to unlocking justice for Donald Trump. As Justice Thomas' powerful words reverberate through the halls of our nation's highest court, the very foundation of the New York prosecutor's victory begins to crumble. With the weight of this precedent behind him, Trump's chances of exoneration have never been stronger. The Supreme Court now stands poised to thwart the politically motivated efforts of the New York prosecutors, reaffirming the principles of blind justice and equal treatment under the law. This is a defining moment not just for Trump, but for the entire American legal system. The world is watching, and the stakes could not be higher.
Congratulations, you made it to the end of the video. Now keep up your quest for truth with this next news report. And if you found our channel enlightening, join the millions who agree with you. Tap subscribe. Thank you for watching the Next News Network.